I hope to be out of business one day. That sounds strange coming from a lawyer, but hear me out. The entire goal of safety technology is to make accidents disappear. Fewer crashes means fewer injuries, fewer lawsuits, fewer victims. But here's the uncomfortable truth we're dealing with right now. Self-driving cars are not there yet, and the companies building them want us to believe they are. We're told these vehicles are safer than human drivers. Tesla says it, Waymo says it, Uber says it, and almost every time those claims are backed by studies that are funded, controlled, or interpreted by the very companies selling the technology. And I don't know about you, but when a corporation tells me, trust us, we ran the numbers, and we're doing great, my first question is always the same. Who's checking the checker? Because experience tells a different story. If you look at the history of personal injury law, you'll notice something interesting. Older lawyers often specialized in aviation law. Decades ago, planes crashed more often, systems were experimental, and the law had to evolve alongside the technology as aircraft became safer. Aviation lawsuits declined, then cars took center stage for years. The most common personal injury cases involved human drivers making human mistakes, speeding, texting, drunk driving, running red lights. But as traditional vehicles became safer, with airbags, collision avoidance, and lane assist, the industry shifted again. Now we're entering the next legal frontier, autonomous and semi-autonomous vehicles. And this is where things get complicated, because when a human driver crashes, liability is straightforward. Someone was negligent. Someone broke the rules of the road. But when a self-driving car crashes, the first question isn't who was driving, it's what failed. Was it the software? Was it the sensor? Was it the algorithm's decision-making? Or was it the human who trusted the system a little too much? Let's talk about real cases, not hypotheticals. On March 18, 2018, in Tempe, Arizona, an Uber self-driving test vehicle struck and killed Elaine Herzberg, a 49-year-old pedestrian who was walking her bicycle across the road at night. The vehicle was operating in autonomous mode. A human safety driver was present but was looking at her phone. The investigation later revealed something disturbing. Uber's self-driving system detected Herzberg multiple times but could not decide what she was: a pedestrian, a bicycle, or something else. Because of that confusion, the system delayed braking. By the time it reacted, it was too late. Uber ultimately reached a settlement with Herzberg's family, and in 2023 the safety driver pleaded guilty to negligent homicide. But the broader issue remained unresolved. The system itself failed, and the public paid the price. Then there's Tesla. On May 7, 2016, in Williston, Florida, a Tesla Model S operating on autopilot crashed into the side of a tractor-trailer. The driver, Joshua Brown, was killed. The car failed to recognize the white side of the truck against a bright sky. Autopilot did not brake. Tesla emphasized that autopilot was only an assist feature, but marketing materials repeatedly showed hands-free driving, reinforcing the idea that the system was more capable than it really was. Fast forward to March 23, 2018, in Mountain View, California. Another Tesla on autopilot crashed into a highway barrier, killing driver Walter Huang. Data later showed the vehicle accelerated into the barrier instead of slowing down. These are not isolated events. They are part of a pattern. And this is why accountability matters. When companies roll out experimental technology onto public roads, they are not just beta testing software, they are experimenting with human lives. And when something goes wrong, someone must be responsible. That responsibility doesn't disappear just because an algorithm made the decision. This is where personal injury law plays a critical role. Lawsuits force discovery. Discovery forces transparency. Transparency forces safer design. Without lawsuits, companies can quietly settle problems behind closed doors, continue marketing half-finished systems, and shift blame onto drivers who trusted the technology they were sold. And here's the thing most people don't realize. Traffic laws still apply to self-driving cars. Speed limits still matter. Right-of-way still matters. Safe following distances still matter. If a vehicle, human-driven or AI-driven violates those rules and hurts someone, there must be consequences. That's not anti-technology. That's pro-safety. Over time, litigation is what will push these systems to actually become safer. It happened with airplanes. It happened with seatbelts. It happened with airbags. And it will happen again with autonomous vehicles. One day, self-driving cars may truly be safer than humans. When that day comes, lawyers like me will have less work to do, and that's a good thing. But today is not that day. Today, these systems are still learning, still failing, and still being rolled out faster than the law can keep up. Until the technology earns public trust through performance, not marketing, companies must be held accountable when their vehicles break the rules and hurt people. Because progress without responsibility isn't innovation, it's negligence. And the law exists to make sure we don't confuse the two.